Benjamin Bryant of Bryant McKinnon Lawyers, and this is Heather McKinnon at Bryant McKinnon Lawyers, and we're just about to start recording our third episode, I think we're up to, Heather, of our podcast. So thanks for tuning in. As we are recording it for the purpose of a podcast, we are on the fly, and there might be some changes, something might go wrong. You might see our producer Steph run out and do something. So if that happens, do not be alarmed. Nothing to see here. Okay. All right, Heather, are you ready to go?
I am.
Excellent. Steph is ready to go, so let's do it. Hi everyone. Thanks for listening in to episode 3 of the Family Matters Show podcast. I'm your host, Benjamin Bryant from Bryant McKinnon Lawyers, and I'm here with my partner, Heather McKinnon. Hi, Heather.
Hi, Ben. It's great to be back.
In case you missed it, last month Heather shared her top tips on how to get a fair property settlement. Dividing up the assets is always one of the most emotional and stressful aspects to separation, isn't it, Heather?
It sure is, Ben. Even in the most amicable separations, once things get strained or when people start talking about money, there's difficulties. I really hope some of the tips we included in the last podcast will help people to take some of the heat out of their property settlement.
And for anyone who wants to access those tips, you will find the episode on the property settlement on our website or wherever you get your podcasts. Moving on to this month, we have opened up the show to questions from the community for this episode. Thank you for all of you that sent in your questions, and just as an aside, your questions are always welcome. Feel free to send them in on Facebook Messenger or via email to familymatters@bryantmckinnon.com.au. Our producer Stephanie will let you know how quickly we can arrange to have your questions answered on the show. Now let's have a look at the questions this month. And Heather, you won't be surprised to learn that the first question is about property. Question 1. When a couple separate, is ownership of the cars automatically assumed to be the person who has the registration, regardless of who actually bought the vehicle?
So really interesting question where we're looking at a particular type of asset, a motor vehicle, which has registration. So obviously in Australia, the state governments all have separate registration systems. Like blocks of land, there is central registry where the government registers the name of who owns the land. In the family law system, we don't care whose name's on an asset. So when we're trying to look at what are the assets of a relationship, it's anything that's owned by either of the partners to the relationship.
Regardless of whose name they're in?
Correct. And it can be company name, it could be held in a trust, it might be held by another member of the family, and when you look behind that you find out they're holding it as a trustee for a super fund, something like that. So the legal ownership isn't anything to do with how the family court determines ownership. So this question about motor vehicles is one that's very common. Many people have a car registered in an entity that's not the husband or wife's name, but for example, they've got a company and all the vehicles are in the company name. One of the spouses is driving a company vehicle. When we do the deal, we've got to transfer the asset out of the company's name into the person who's going to take it under the orders. So the short answer is there's no automatic ownership just because your name is the one that's on the title to the asset. It all goes into the melting pot.
So registration doesn't denote ownership.
Correct.
And I note that when you're doing an application for a transfer with the RMS, RTA, whatever they're called today, Services New South Wales, it's a transfer of registration. It's not a transfer of ownership. Other things might come into account as to who owns that particular vehicle. For example, there might be secured finance attached to it or some kind of sale documentation to that person. But like what you were saying, does it really matter whose name the car's in when it's a relationship of 40 years? And I assume we're not talking about Lamborghinis or any other significant asset like that where perhaps it is the major asset in dispute or the major asset of the asset pool. I would think in most circumstances it's not.
Yeah, and so what we want people to get into the habit of understanding when they're listening to the information we give them about property settlement is the first step in assessing it is what are the assets, not whose name are they in, but what are the assets that either of them control in whatever way. So the vehicle will go into the balance sheet and to be dealt with like all the other assets, and then when we come to look at who takes the vehicle, that will go on to their side of the balance sheet. So for example, often we see cars swapping ownership in the settlement because one person will decide, look, I'll have that vehicle rather than that antique table or whatever the deal is. So it is important to get your head around the fact that legal ownership to the outside world is not what ownership means under the Family Law Act.
And I think that's a great point, Heather, that you raise in terms of any agreement reached. For example, mum might get the Kia Carnival or the 7-seater or whatever the case may be if she's a primary carer for the children, and it may be in her possession or transferred to her possession but registered in the father's name. So perhaps there is, in terms of the question, when you've got an agreement, you need to be careful at that assumption that even possession denotes ownership, because you have to be careful that when you're in a property settlement, that if there is something that needs to be done, i.e. someone signed a transfer of registration with the RMS or Services New South Wales, that it be included in the property settlement at that moment, so you don't get a situation where you think you've agreed to something, but in the end, actually, you haven't.
Yeah, and look, it is so important with vehicles. Often it'll be the case that people do a handshake deal on settlement, they don't go near lawyers, and when they get into real difficulty is 2 years down the track, they're driving along the highway and they get pulled over for unregistered vehicle because the rego renewals aren't in their name and the spouse didn't tell them when it came up. So there's all sorts of reasons that you've got to check off that at the end of the day it comes onto your side of the ledger, it's insured in your name, and the rego information that's required is going to come back to you, not to the ex.
And we're lucky in Coffs Harbour because, of course, we don't have any road tolls, but we do have 2 red light safety cameras now. And of course, this is a common question that we get when people come and see us, and we've addressed some of the things that we've spoken about now in our property settlement fact sheets, which we've uploaded on our website, and we'll make sure they're available after this podcast.
Yeah, so just keep going back to those documents that you see on the website, and that gives you that layer overview of how the whole thing works.
Our next question, Heather, is in relation to a parenting matter or parenting question. The question is, do you have any suggestions on how to work out joint parental orders when one parent is fly in, fly out?
So in the area where we work, when the mining boom took off, anyone who went to the airport would see literally hundreds of fly in, fly out workers. But if we step back further, there's always been a large contingent in Coffs Harbour of 2 particular FIFO workers, airline employees, particularly people like the captains of different, Qantas, Thai Airways, and that's, credit to Coffs that those people want to live here, but their lives mean that they go in and out of their children's lives differently to 9-to-5 workers. And the other big group that are used to this are naval people, and we have, again, a large population of naval employees with kids living here. That's because it's one of the most desirable locations. So we have a history of helping parents long before the mining boom work out what you do with little ones if one parent's absenting themselves for weeks or months at a time. So the first sort of advice that we give all parents is focus on the needs of your kids. Some little ones adapt really well to living with one parent for a couple of weeks, and then when dad or mum are back from their work roster, they shift to that parent's home for a week, or whatever the deal is. Other little ones find it almost impossible to deal with that absence change. A lot of that is to do with the age of the kids. So if you separate when you've got toddlers or babies, it's really important that you get some social science input from a really good child psychologist who can help you both understand the developmental needs of a child. The last thing you want to do is develop in a very young child an attachment disorder, because in all good faith you thought that it was okay to have, you know, a little one going to mum or dad for a week after being with the other parent for 3 months. This work is really complex, it's difficult, it needs very personal attention to the needs of every child in the family. So my advice is access the Family Relationship Centre and good child psychologists to help you as a couple work out how we're going to set up for the pattern for the kids. You know, we've seen every sort of example, I suppose, Ben. We've seen that, you know, orders that provide that whenever the fly-in fly-out workers onshore, they will have the kids. We've seen others that just provide that when the other parent's onshore, they have the non-school days. Every family is different. You know, you've got some good practical examples of what we've seen in terms of building attachment.
No, of course, and I think one resource that I send clients to, Heather, is Children Beyond Dispute website, which we'll make sure that's in the show links. It's a great resource to help, as you said, the social science, help parents with the social science of age-appropriate arrangements for children and what is normal or what can be expected of children of particular ages to do. But at the same time, I think we also, you know, encourage parents to have flexibility, especially with fly-in, fly-out work, because the roster can change. You can be laid off, you might change companies, and that can all happen at short notice. And even though the fly-in, fly-out work is great during the relationship, it means usually a high income, means you get to live on the coast, different things. Like with any other issue, what you revel or take joy in the relationship becomes something nasty or becomes ammunition at the end. And it may well be that children can cope with spending time away from the primary carer and time with the fly-in, fly-out worker separate from the primary carer, because that's what they were doing during their relationship. Perhaps the parent that has the primary care of the child also worked full-time, so it was not unusual for them to be with someone else or a daycare, and they have, you know, really adaptive or resilient, you know, features. So I think flexibility is key, but also an important thing, Heather, of course, is reasonable practicability in matters when a court's assessing what's in a child's best interest. We know that usually the court is spending a lot of time on weighing up a child having a meaningful relationship with both their parents and a child being protected from risk of harm, serious or unacceptable risk of harm. That's what's taking up a lot of the court workload. But in a fly-in, fly-out situation, there mightn't be any allegations of family violence or child abuse or anything like that. There mightn't be any allegations of parenting capacity or lack of relationship between a child and a parent. The question might come down to reasonable practicability, because that's, a court can only ever make a parenting order that's reasonably practical in the circumstances, and that can be very difficult in a fly-in, fly-out situation,
And look, I'd say that most couples that have been in that pattern for long periods of the children's lives never end up in a big dispute, because the very nature of the relationship meant that they've already had to learn how to live apart, how to communicate at distance, and how to put the kids first. So in fact, we see most FIFO families coming in and out of the system pretty quickly. And I think another part of that is there's more money to go around, so the stresses aren't as much as they may be in other families.
And I encourage this viewer as well, or this listener, to touch base with some mediators as well, to really, the benefit of a mediator is that they facilitate communication. Sometimes when you're most of the times when you're separating, communication is not at its strongest, and perhaps there's no communication. And this viewer or listener really does need communication with their ex, with the other partner, to really work with the roster and see what the children can and can't do, and how there might be a way forward, notwithstanding this peculiar roster situation.
Yeah, definitely.
Question 3. This one is a very common question that we get, and I know people listening or viewing us right now are feeling this right now. So I really, really like this question. The question is, I'm preparing myself to ask my husband for a divorce. I'm really nervous because I don't think he sees this coming, and he's likely to react really emotional. Do you have any recommendations on what I need to do to have prepared before I start the conversation?
Yeah, I mean, after decades of doing this work, I can tell listeners that this is the hardest conversation that you'll ever have in your life. And in fact, what we see is people delaying the conversation for some years sometimes. So they live in these very maladapted situations because they're too frightened to have the conversation. So let's go back a bit. You know, what I think is the best way ever of communicating is directly. But in this situation, we have to be very careful because we know that the most risky time for anybody is the day of separation. So if you have an underlying concern that your partner may react outside the normal range, treat it seriously. So what sort of recommendations I would make is either role play the conversation with your counsellor so that you get some idea of what it might be like. Or if you're really concerned, then what you do is ask your partner, can you see that we might be having some difficulties? Will you come to counselling at somewhere like the Family Relationship Centre?
And do it in a safe setting or a
safe setting. And what tends to happen there is each partner is allocated a counsellor. So the counsellor can deal with the partner who's been in denial and help them process their emotions in a more appropriate, safe way, so that there's not a lot of damage wreaked on the household from someone who's unsupported. So, you know, that is a really successful way of getting to the point, because what tends to happen in those sessions is that both people realise they've been flogging a dead horse for a while. So they are able to reach a mutual decision to separate rather than it being one person.
And if people are not comfortable using a counsellor, or if they don't have an ongoing or existing relationship with a counsellor, perhaps there might be a mutual trusted party or friend that the couple can use. And it's interesting you said the party that's in denial. What struck me then, I was explaining to someone just this morning, Heather, was that in almost all circumstances, separation is not impromptu. It's not something that we wake up and we decide on a whim. It's something that at least one party has thought about for some time. That party has thought about, what's Christmas going to look like? Who's going to get the dogs? Do I need a separate bank account at this point? Who's going to pay for what? All these different things one party's thinking about. And of
Sorry
course,
guys, can you stop for a second? Jason?
Yeah.
I can hear that really loud. Can you just try and stay away from this side of the thing? Thanks. Sorry.
So what I was saying, Heather, was that one party has been thinking about this for some time, about separating joint bank accounts, who's going to get the dog, what's going to happen with the children in the school holidays, who's going to pick them up from school, all these different things. And the other person, of course, has no idea this is coming.
Or no conscious idea.
No conscious idea, that's right.
Yeah.
I knew things were bad, but I didn't think they were this bad. And so with a party who is planning, they've essentially had time to grieve already. They've been putting this in, they've been planning this, and then you break the news, you take the leap of faith, you break the news, and then that party generally expects that the other party just needs to get on board and move on, start progressing, this is what we're doing. But of course, that party who didn't consciously see this coming needs to quickly hurry up. They need to grieve, they need to get sad, they need to get angry, they need to feel all the things that the other partner felt, but has to do it in a really, in a short time. So I think there's always, there's always not necessarily a power struggle, but everyone going through the, similar grieving process, because that's what it is, grief at the end of a relationship. But people are at different parts of the bell curve on the grief cycle. So I think it's really important that partners, when they separate, are just really conscious that the other partner might have to catch up, or so when they're acting really emotionally, that could be a perfectly normal response. Okay, of course, if there's any risk factors or if there's anything like that, you always call the police or family community services, whatever the case may be. I'm not suggesting that, but what I'm suggesting is that an emotional response could be quite normal, because this viewer might have had that time to put herself in that space, and now we really need the husband to get in that space.
Yeah, and that's what all our work is. Our work is usually about the conflict between the one that's been out of there for some time and the one in denial catching up, because that's where you get the most serious sort of behaviours as people throw out their unprocessed emotion onto the legal system rather than dealing with that in a different setting. So we're very aware of that, and we help people to try and understand that.
Absolutely.
And so if we get the denier, we will try and get them to process that emotion appropriately rather than get into a big conflict.
Yeah, because that's, as I've said in previous shows, that's the thing that I love about our job, is that even though this person has come in most likely soon after separation, and they can't see what lies ahead, or they think they might have an idea of what lies ahead, but we know what lies ahead, because we do it, day after day, the process, and it really is about trying to manage people's expectations and making right decisions. But we can only manage it so far. For this viewer, I would say, or listener, I would say that there's always an element of leap of faith. You know what I mean? We can help, we assist with bank accounts and child support and put all the, the ducks in a row, but at the same time,
it's hard.
It's a leap of faith.
Yeah, and it's no point, saying it's going to be easy. It's not going to be easy.
On to our fourth question, Heather. My wife has mental health problems, bipolar disorder specifically. I'm very worried about the children spending extended periods of time with her on their own. Do you think it might be possible for me to get sole custody?
Okay, so this is the pointy end of the work that we do, and what this work involves is the assessment of risk to children if one or both parents has a mental illness. The first thing that I would say, Ben, is that many people come to us saying that their wife is a narcissist, or that their husband has bipolar disorder. And in fact, when you drill down, that's a diagnosis that's been made by the spouse on the internet.
Yes,
they've just talked to their friends, or they've read all about narcissist online, or they've read about bipolar, and in fact, there's never been a diagnosis. But what we're going to assume here is that it is a spouse who's been the carer for someone who has managed their bipolar disorder illness for the relationship. So when we're looking at particular categories of mental illness, we have to have an understanding of which ones are able to be managed well within our current knowledge of mental health, and whether this particular parent has insight, has a long-standing therapeutic relationship with a psychiatrist and a mental health team, and whether there's been any indications during the relationship that the parent was in some way acting in a way that harmed the kids psychologically or emotionally. The risk assessment can't be made by lawyers. In a situation like this, if the person came to us, we would initially be saying to them, ask your spouse whether they're prepared to have a session with the treating psychiatrist to get some understanding of what's ahead, what the nature of the illness is and how well it's managed, or to get a report from the treating psychiatrist that's been involved with that patient over a long period of time, indicating that the person is well managed, they have regular appointments, there's no indication that their symptoms are going to worsen or that there'll be any risk to the children. They're the sort of practical things that can be done to help people make decisions, and depending on the insight and the willingness to cooperate, the family can often move on through separation without any need for anything else. But if we get a case where there is instability in the parent, that involves some very serious investigations into what is the nature of the illness and what risk does it pose. So without being alarmist, that's the sort of issue that we look at in the Rosie Batty family, where that mum tried to manage the father's mental illness herself, believing that she had an understanding of the risk, and so had the little boy seeing his dad in public places. We all know that that wasn't good enough, that what in fact happened was the father was able to kill the child in the presence of other people. So the most extreme examples of untreated psychosis are where we see the death of a child. As family lawyers, we have to manage that risk by understanding the nature of each mental illness, understanding which ones are ones where you have to have very sound assessment, remembering that somebody who's been in a very supportive relationship with a carer spouse is at high risk of what we call decompensating at the time of separation, because stress is often what will exacerbate symptoms. So in this case, can we do anything to help this person? Not without very good understanding of psychiatric evidence available and some understanding of how long the other parent has been stable and whether the separation poses risks for that person to destabilise. So hopefully that gives a sort of an overview. Many parents who have mental illness are very successful parents. They are able to manage their condition, they are able to deal with their lives in a way that they parent highly effectively post-separation. We don't know in this case what the go is, but certainly the family law system is there to assist parents to assess risk in cases like this.
That's right. So I think the first you look at, as what you were saying, was look at any formal diagnosis. This viewer or listener has mentioned bipolar disorder. For example, you just gave an example with an episode of psychosis. It could be bipolar, disorder, affective disorder, bipolar affective disorder. And it's not enough to simply have a mental health issue or be diagnosed. It really needs to be linked to parenting capacity, because as you pointed out, there's a lot of perfectly functional parents out there with mental health issues. It's not a case of, so you've got a mental health record, that's it, you're not going to see the kids, or you'll never be the primary carer. And in fact, it can be a great thing, because if you've had a mental health problem and you've addressed it, and you're working with your treating team and you have records showing that, that can be a great thing, because it can say that you're one that is protective to your children, or that you are one that has insight into their mental health, not mental illness, into their mental health, and you can take the necessary actions or necessary steps to make sure that you're perfectly healthy and functional. And that, in some ways, can be a lot better than parents that try and minimise it or try and perhaps hide their mental health issues, and it only comes up later on. So I think linking it to parenting capacity is a big thing, but also again talking about Section 60cc or the Family Law Act, or when judges are assessing what is in a child's best interest. So again, a lot of people just think that's a overall kind of statement or overall consideration, and it's not. Section 60cc clearly sets out the criteria that a court has to assess or work through as a checklist in determining what's in a child's best interest. And the two primary considerations, Heather, we know, is that assessing the risk of harm and a meaningful relationship with both their parents. Okay, so again, it comes down to trying to balance that and getting as much information as we can to make sure that children are safe in an environment that provides, sustains having a meaningful relationship with both their parents.
Exactly.
Heather, our final question. My partner and I have been trying to manage our separation without getting lawyers involved. We've been doing pretty well, but have recently come up against disagreements on the value of the house, that's a common one, and how to manage the division of the asset. Is it possible for me to engage a mediator to help us work through this without having to involve a lawyer?
Certainly is, and we lawyers are only involved in about half of the cases where people separate. About 50% of the population do it without going anywhere near lawyers. So it's very common. Mediators are there as an alternative dispute resolution method, so they can help you try and work through the resolution of issues without legal advice. There are lots of resources online that can help you locate mediators. The family relationship centres have programs for mediation where the asset pool is small, as do the Legal Aid Commissions of New South Wales. So this all depends upon how much money is for division. If it's a modest pool, then Legal Aid and Family Relationship Centre have mediation programs. If there's more money in the pool, there are private mediators that you can access who can help you try and work through a process. For example, how do we appoint a valuer? How do we agree on what we've got to divide, and what might we be able to divide at the end? So by all means, you can feel free to do that. Most mediators will tell you whether they think it's one that's appropriate for non-lawyer mediation, or whether it's one where there should be lawyers involved. And again, it's usually to do with the complexity of the asset pool.
And sometimes you might need legal representation. Perhaps you can use a mediator, reach an agreement with your ex, and then see a lawyer to get legal advice on that. And two things that I wanted to say to this viewer, Heather, is that one is the valuation issue. Of course, the house, the valuation issue, very common. I know we've addressed that in previous shows, so I encourage the viewer or listener to check out our previous shows. And I know that we're going to cover valuation issues more specifically in future shows, so I would encourage the listener to keep touching base with our website to check out what's on, because we absolutely will be talking about this issue some more. The other thing I would say is in respect to the transfer of real property. It may be that parties can reach an agreement that someone's going to retain the house, and so it needs to go from joint names to the husband's name or to the wife's name. But of course, if you don't have orders in place by the court or a financial agreement, stamp duty may be payable in some circumstances. So it's really important that at some stage, I think parties get legal advice or financial advice or whatever the case may be before locking in their deal, to make sure that it is realising the intention that they've set out.
Exactly. We'd hope that they can do it without help, but there are some times when you do need us, unfortunately.
Thank you, Heather. And thank you again for all your questions. Family separation is a difficult and confusing time for everyone, and there are always going to be questions. So please feel free to message or email the show at any time, and we will do our best to make sure your questions get answered. One area where we don't get enough questions is self-care. People tend to focus on property and children and lose sight of the impact that divorce is having on themselves. And actually, your own health is absolutely critical when you're going through separation. Let's face it, You are going to be negotiating agreements and making decisions that will affect the rest of your life. You want to be emotionally and physically well when you are making those decisions. So next month, we are delighted to welcome Monica Joseph to the podcast to talk about self-care during separation and divorce. Monica is a Medicare accredited social worker who provides counselling on a wide range of issues, including relationship difficulties and breakdowns. Monica is a really practical person with training in mindfulness, relaxation techniques, assertive communication, and other skills that will help you best through your difficult time in your life. I hope you will be listening because this is such an important topic that doesn't get enough attention. A final reminder that links to any resources mentioned on today's show will be available in the show notes on our website. If you have specific questions about self-care for Monica Joseph, please send them via Facebook Messenger or by emailing familymatters@brianmckinnon.com.au. Goodbye for now, and we hope you'll be listening again next month.